And you scheduled this for a default
Yes, Your Honor.
and sent me a proposed journal entry, which I appreciate.
Yes.
We're gonna go on the record in this case, 2025 DM 244. Is your client with you or are you appearing on her behalf?
She's on Zoom, but we're in different locations.
Okay.
I believe that's Sarah Geens on the Zoom.
Okay, I'm not seeing that. I've got it on gallery. There she is. Good afternoon. But obviously Mr. Horton has appeared. I did see that you gave him notice of hearing. I wasn't sure. It looked like your client lives in Augusta, correct?
Yes, Your Honor.
Okay. And so he was served in like Winfield.
That's correct.
Okay, and I was curious because the notice of hearing went to Augusta to him rather than the Winfield address that he got served at. But he is here and he was served with process by your special process server with the summons and the petition back on July 17th.
Yes, Your Honor.
So that's certainly more than 21 days. And the petition was filed
July 8th, Your Honor.
July 8th, so certainly we've got our 60 days, which is the waiting period in Kansas, but I'm not sure how we should proceed at this point. Mr. Horton, when you were served with the summons and petition, it says in there that you're to file an answer in 21 days, and you've not filed an answer, which is why they were going to pursue, nor did you hire an attorney who entered appearance or anything else, which is why they were going to pursue a default judgment. And had you not appeared today, I probably would have granted it. Now, default judgments are not preferred in the state of Kansas, and they can often be set aside up to 1 year if depending on the circumstances. But so we want some finality here, obviously, and no basis to file a motion to set anything aside, but technically you haven't responded. So counsel put together a proposed journal entry and decree of divorce that he wanted me to adopt today if you didn't show up for the hearing. And you probably haven't seen that, have you?
Your Honor, Mr. Horton actually did send a response on Friday with one proposed change to that journal entry. I think he sent it to your office as well.
Okay, I did not receive that. And I am working remotely today, and I had an event this weekend in Kansas City, and I've got to take somebody to the airport late this afternoon. And so I'm not in my office either.
Okay.
Which generally I am, even when I'm working by Zoom. Are you saying that he actually filed an answer with the clerk on Friday?
No, Your Honor, he sent an email to your aide that I was CC'd on. We had put a pickup date for his property. Back when we originally drafted this, we'd put it as September 21st because that was after the 60-day waiting period. But obviously that's before this hearing that we were able to get in front of you for. So he was asking that date be pushed further so that he can actually pick up his property, which is certainly reasonable. But I don't think he had any other objections.
Okay, so but we're still back to square one in terms of he didn't file an answer. But the answer to whether or not you've seen the journal entry is yes, you have looked at it. And there's only one thing, and that's you need a little bit more time to pick up your personal property.
Hey,
yes.
Mr. Horton, you're on mute. Sorry, Your Honor, I didn't mean to interrupt.
That's okay. That's okay. There we go. Is that all? Are you in agreement with the journal entry and decree other than the time frame to pick up your personal property?
Yes. I understood that I didn't have to respond if it was, I'm not contesting any of it. So that's why I didn't do any of that. So
Okay, well, that's fine, but you also haven't signed the decree, which means it isn't a decree by consent. So let's do this. Let's take some testimony today from your client, Mr. Baxter, and then you modify the date in this hearing. And then you send him the journal entry decree, let him sign it, your client sign it, you upload it, and I'll sign it.
That
So we
sounds
won't need to have another hearing waiting on all of this.
sure.
Okay, sounds good. So, Mr. Horton, if you approve, other than the time frame, and it gets sent to you, then you need to sign it by agreement. Make sure the attorney gets it back with the signature, and then he'll upload it electronically into my queue, and I will sign it. And I'm just gonna go ahead and conduct the hearing now, assuming that that's all going to take place, okay?
okay,
Do you have any questions?
nope.
Okay, Sarah, if you would raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. And there you go. Yeah, you need to turn your audio on.
There,
There
I
you go.
do.
There you go. Okay, thank you. Mr. Baxter, you may proceed.
Thank you, Your Honor. Sarah, can you go ahead and state your full name for the record?
Sarah Diane Horton.
And Sarah, are you the petitioner in this divorce action?
Yes,
Okay. Where do you currently live?
at 14638 Southwest US Highway 77 in Augusta.
And that's in Butler County.
Correct.
How long have you lived there?
Little over a year now.
Sarah, are you asking for the court to grant you a divorce from Matthew Horton today?
I am.
And did you in fact you filed a petition and we filed a request for temporary orders, which was signed by the court? Do you recall doing all that?
Yes, I did.
And you understood that when we filed that we had to wait 60 days before we could proceed with a divorce under Kansas statutes?
Yes,
Now, given that we've waited that 60 days, do you still want the court to grant your divorce?
I do.
Now, have you had a chance to review the proposed journal entry that we've submitted to the judge?
Yes,
And did you approve of that before we sent it off to the judge?
yes,
Today you've heard us talk, and I spoke with you before this hearing about a change in date for the pickup of property for Matthew, that would be at a later date. Do you recall that?
yes,
Are you okay with changing that date so he can pick up his property?
I am.
Do you have any other concerns with the proposed journal entry we've submitted to the court?
No.
All right. Well, Sarah, I don't have any further questions for you at this time.
Okay, thank you.
Thank you.
So how much is owed on the residence there on 77?
The escrow is over, so it's basically, it's pretty close to what I started out, so like 259,000, roughly thereabouts. Do you want an exact figure, Your Honor?
No, were you, you've only been married a couple of years, is that right?
Yes,
Was this a home that you owned prior to the marriage?
it was not.
Okay, so you bought it during the marriage, but you've owned it less than 2 years?
Yes,
How long have you guys been separated?
since July.
Okay. So there's really not any equity, so to speak.
No, it's a negative equity, actually.
Okay. And you're asking that the property be awarded to you.
Yes,
And since it was a short-term marriage, there's no substantial retirement or pension that you want to share.
took what I had to put into the house, so I'm basically starting from zero, and no, I wasn't asking for anything from him.
Okay. And then there's no request for any spousal support or maintenance. And the debts,
No, I was fine with us just taking what each of us had and splitting, going our separate ways.
okay. And in the number 2, it says he's responsible for rent, mortgage, but you're not talking about the mortgage in Augusta. You're taking the house, so you're taking the mortgage with it.
Correct.
Okay, all right. And there's no equalization payment and, okay. So, Mr. Horton, and you believe it's fair, just, and equitable? The division,
Yes.
okay. And of course, there are no children in this relationship.
No.
Mr. Horton, will you raise your right hand, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay. First of all, did you have any questions of Sarah based on her testimony she just gave?
No.
Okay, so you've had a little time to review the decree. Do you agree to her taking the marital home and being responsible for it?
Absolutely.
Do you understand that you had a right to consult with an attorney about what you may or may not be entitled to?
Yes.
And the court is not acting as your attorney, so I'm not advising you of what you may or may not be entitled to. Or what,
Understood.
okay. Now, I will say this, though. You do understand that she's not being required to refinance the residence for 48 months, which means that may prohibit you from purchasing a home until your name is off the promissory note, the mortgage.
Understood.
Okay. And did you plan, Mr. Baxter, for him to go ahead and stay on the deed though until his name is off of it?
Well, I suppose, yes, we did, Your Honor.
Okay. Sarah, was there something that you wanted to say?
It is my name solely on the mortgage and the deed.
Okay,
So that shouldn't be an issue.
okay, I did not
In my-
realize that. I apologize.
That's okay.
Because there's a provision, isn't there, in here for 48 hours or 48 hours, 48 months time to refinance? Or am I,
Pulling it up now, Your Honor, I apologize.
but yeah, if he didn't sign to purchase, he doesn't have any legal
No.
obligation. He has a marital interest, but he has no legal obligation to the mortgage company that you signed the promissory note with. Okay,
Yeah, it looks like we just left that in there as a kind of our format or like base form that we use.
Would you
But-
pull that out? please, and
Absolutely.
just keep that quick claim. So Mr. Horton, when I award the house to her, you're going to need to execute a separate quick claim document that they can file with the Register of Deeds that says, I mean, the court order, which when they do a title search, they will find and see, says it's her property as of this day. But it also makes sure that any successive buyer is cleared title-wise, because you're also saying, this is free and clear of any claim or any future claim that I may have to the property. Okay, so that is required of you. All right, very good. And then so long as you get that a little bit more time to retrieve your personal property, you're okay with everything else,
Yes.
including no spousal support. Okay. And you believe this is fair, just, and equitable.
Yes.
And you understand that she wants a divorce, and I'm in agreement. This is a no fault state where if a person wants a divorce, essentially they get it.
Understood.
Okay, very good. All right. The court finds, after a review of the file, having heard from counsel and reviewed the journal entry and decree of divorce, as well as hearing testimony and statements from the parties, the court has jurisdiction of the subject matter and personal jurisdiction. Mr. Horton was served, he appears, he understands the nature of this agreement and the provisions, he understands his right that he could have consulted with counsel. And I mean, the court would have continued this case if he had requested to seek an attorney, that he is in agreement with this finding that it's fair, just, and equitable. There are no children of this relationship. There is real estate, but it is solely in the petitioner's name. She is awarded the marital real estate. The debts are divided as set out in the decree. And again, the court finds that it's fair, just, and equitable. Last but not least, the court finds that the waiting period has elapsed, that these parties are incompatible with their reconcilable differences, can no longer live together as husband and wife, and I will grant an absolute decree of divorce. There is a 30-day waiting period to remarry. That is also an appeal period in the state of Kansas. So the 60-day waiting is on the front end, the 30 days is on the back end, and that's from the date the decree is filed. And so it will be circulated, given to me. So if it's uploaded and I don't sign it until, say, Thursday or Friday, then you get a certified copy of it, and that is your actual legal date of divorce, where the 30 days starts running. Okay? Mr. Baxter, anything further?
Nothing further, Your Honor.
Okay, any questions, Mr. Horton?
Nope.
And there was a request that of a name change as well, wasn't there, Sarah?
Yes, back to my maiden name,
Which is,
Jones, Jones.
okay, and I will order a restoration of your maiden or former name to Jones as well.
Thank you.
Okay, all right, everyone take care. Thank you.